Who inherits your love story? Love lasts forever, they say, but what happens to your assets when you've gone? If you don't have an estate plan, your loved ones might not inherit what you intended. I'm Julie King, an intellectual property business and estate planning lawyer with King Patent and Business Law. This Valentine's Day week, I'm talking about the intellectual property of love. But what I'm saying applies year-round. If you pass away without a will, state law decides who gets your assets. And if you're not married, your partner may get nothing, even if you've been together for years. And if you have a blended family, default state law doesn't pass anything to your stepchildren. If you want them to inherit anything, you must have a proper will. Make sure you keep your beneficiaries up to date on life insurance policies, bank accounts, retirement accounts, and any other kind of account capable of having payable-on-death beneficiaries, especially after marriage, divorce, or having kids. Outdated beneficiaries can cause huge legal battles. Have you ever thought about what happens to your romantic emails, texts, or social media? A digital estate plan ensures your online memories go to the right person and are handled correctly. In a will, you can leave specific items to specific people. Say if you want your best friend to have your record collection, you can just say so in your will. If you don't have a will, the person handling your estate may not know of your wishes, and the default law doesn't leave anything to friends. If you own any part of a business, a proper will is a must, so your wishes regarding your business interest are honored. Important, the provisions in your will match the provisions in the business's operating documents regarding what happens when an owner dies. Sometimes, people want to make sure that none of their estate goes to their spouse's new spouse if they ever remarry. And that's not something that necessarily is spiteful. That just means that they want their estate to benefit their spouse and maybe their children, and not a new spouse or the new spouse's children. And there's nothing wrong with that. But this is something your estate planning attorney can work with you to plan. If you don't have any formal will or trust, though, you have no control over what happens to whatever share your spouse inherits. They can do whatever they want with it. And what about your furry family members? Did you know that you can provide for your pets in a will or trust? It's true. You can say who you want to have custody of them and even set aside money for the pet's care. And if making charitable donations upon your death is important to you, have a will made that says exactly what you want to donate to which charities. If you don't have a will, by default, nothing goes to charity. Now, wills are for handling your estate after you die, but what happens if you become unable to manage your health decisions or financial assets while you're alive? That's where powers of attorney come in. Powers of attorney state clearly who you want to be in charge of making those decisions for you if you can't make them yourself, how you want it to be determined that you're incapacitated, and what decisions they can and can't make. A power of attorney for healthcare can also state what you want in terms of heroic measures to prolong life and your wishes regarding organ donation. Powers of attorney make things much, much easier for the person who needs to take over for you when you need help. Finally, a well-planned estate protects the people you love most. This Valentine's Day, show love by making sure your affairs are in order. And for couples, while nothing says romance like confronting your mortality together, I advise not making estate planning your only gift to each other if you want to have a nice Valentine's Day together next year, too.